Welcome back, everyone. Today's hearing is one you won't believe. On the docket, Lupe Gomez. Now, from the very first words out of his mouth, Gomez starts playing legal word games, calling himself a third-party intervener instead of a defendant. Confused? So was the judge. What follows is a clash between courtroom reality and sovereign citizen-style theatrics. But stick around, because just when you think the case might spiral into nonsense, a single missing officer derails everything. And later, another defendant gets grilled for smoking weed while out on bond for a serious felony. Trust me, this one has twists you don't want to miss.
All right, 23 DCCR 0319 on Lupe Gomez. I've got Mr. Nichols here for the state. Mr. Radford is here. Sir, you Lupe Gomez.
I'm sorry?
Is your name Lupe Gomez?
I'm the non-corporate
What?
third-party intervener, cross-plaintiff, superior lien holder, to be prepared by special restricted visitation and not by general appearance.
Can you do this? Can you come around and have them so I can see better?
You want us all to bench up?
Yeah, y'all can all come up here. Okay.
So I have a couple questions.
No, well, hold on. You don't get to ask questions. I'm going to ask the questions, Mr. Gomez.
Can happen until all parties are identified into the record.
All right. So, Mr. Tell me again who you are. Who are you saying
I'm
you
a
are?
non-corporate third-party intervener, here by special restricted visitation and not by general appearance, under duress by the means of threat, coercion, and kidnapping.
Did you hear that? Gomez isn't even admitting who he is. Instead, he's spouting this bizarre, pseudo-legal jargon. Corporate third-party intervener and not by general appearance. This is classic sovereign citizen playbook, where defendants try to dodge jurisdiction by claiming special status. Judges have heard it all before, and notice how quickly she shuts him down. I'll be asking the questions. It's firm, controlled, and it sets the tone that theatrics won't win in this courtroom. Question for you. If you were the judge, would you have given him any patience or cut him off right there?
Okay. Have you ever been known by the name of, in the past, Lupe Gomez?
Will you state your name for the record, please? And will you order the prosecutor to state his name for the record? And do either one of you have a claim against me?
We do have a claim against you. My name is Raquel West. I'm the judge of the 252nd District Court. This is Mr. Luke Nichols. He's one of the assistant district attorneys in my court. Mr. Radford is here representing you.
Okay.
There's an indictment. There's a motion to quash. Mr. Radford has filed that we're here for today. I'm going to take judicial notice of the court's file, which includes numerous documents, including a indictment, the probable cause affidavit, other identifying information that does identify you as Mr. Lupe Gomez. And I'm going to make the finding at this time that you are, for purposes of this hearing, Lupe Florencio Gomez. And we're going to go forward with the motion to quash. Mr.
What's a motion to suppress?
Motion to suppress. I'm sorry. Let me get that pulled up. I have a motion to quash as well, correct?
Yeah, you do.
Hold on.
I think that's a pro se motion.
Okay, so we're here on Mr. Radford's motion to suppress. Let me find that one. It's okay. I'm looking.
Well, while you're doing that,
Nope, stop talking.
Onto the record,
Stop talking.
Your foreign agents and registration statement.
My what?
Are you refusing to do so?
I am.
Okay.
Here we go. All right, so Mr. Radford filed, it's entitled Motion to Quash and or Suppress Evidence.
Oh, okay.
And that's why I was confused because it just showed the first part. In 23 DCCR 0319, this was filed April 29th of 2024. And Mr. Nichols, you may call your first witness with regard to the suppression.
State calls Officer Chad Morrison.
Would you please call the name?
Officer Chad Morrison. No response, Your Honor.
All right, Mr. Nichols.
Your Honor, I have no other witnesses in this time for this hearing. The state rests. May I make a statement on the record?
Yes, you may.
Your Honor, I was in contact with Officer Morrison last week. He is formerly of Port Arthur Police Department. He now is with a different agency in the greater Houston area. He indicated he is on injury leave at the moment and would not be appearing for this hearing. He was also on injury leave and was unable to appear last time we were set for this hearing, approximately 2 months ago, maybe in May. So that at this point, the state has no other option but to rest in this hearing and present no other evidence.
All right. Anything, Mr. Radford?
No, ma'am.
Well, based on that, then unfortunately, I have no choice at this point, which is unfortunate that the officer won't comply with showing up, but I'm going to grant the motion to suppress evidence in the case based on the fact that there's no evidence today.
And there it is. The entire case crumbles because the arresting officer doesn't show up. No testimony, no evidence, no case. The judge is almost frustrated, saying, "Unfortunate the officer won't comply." But legally, she has no choice. Without evidence, she must grant the motion to suppress. That means Gomez walks. Case dismissed. Think about that for a second. All the legal word salad didn't save him. It was the state dropping the ball. Here's the takeaway. In criminal law, procedure matters as much as substance. No officer? No conviction. Would you call this a failure of justice, or the justice system working as it should?
Mr. Eccles, when did you smoke pot? Why would you do that when you know you're coming to court for a second-degree felony offense? It's common sense that you're on bond for a felony and you're coming to felony court. No one should have to tell you to follow the law, right? I'm going to raise your bond it is a bond condition that you follow the law. So when you made bond, part of your conditions was that you follow the law. You haven't followed the law.
Did you catch the irony? Gomez is celebrating a dismissal, but then admits he smoked weed while out on bond for a second-degree felony. The judge absolutely pounces. Why would you do that when you're facing 20 years? This isn't just about marijuana. It's about judgment. Out on bond means you're being tested. Can you stay clean and prove you're trustworthy? Instead, he makes the one mistake guaranteed to hurt him in court. And the judge brings it back to real life. How does this help your 3-month-old daughter? That's a dagger. It's no longer about legal theory. It's about responsibility.
Sure.
I'm 27. I've never had any drug charges, anything like that. I'm gonna be honest. I know I shouldn't have been smoking, but in my head, I'm saying, okay, I'm not going for a drug charge. I don't have prior drug charge. I didn't know there was a possibility that I would get tested. It's not a problem for me to start smoking. It's not. I could have a tattoo. The bond's been paid on time. I'm not a bad person.
Okay.
I just thought, okay, you're not.
Here's the thing. If you can take care of all those things, then you can also hire a lawyer.
I'm just not working. I could have a tattoo. I just stopped working. Just stopped. Let's say my daughter's 3 months. I was working as a certified surveyor.
So, but there's other companies out there that you could be looking to get a job, and they're not going to take you if you're testing positive. So I'm not saying you're a bad person. Most of the people here that are in front of me aren't bad people. They're people who are making very bad choices, which is what you've done, right? Probably on more than one occasion. So if you don't have a problem doing that, I mean, we've got a couple of things going on here. Number one, if you were working for Zachary, I'm not real sure why I appointed you an attorney back when, okay. So you should already, if you have all those certifications, there are other companies out there. You don't have criminal history right now. You should be able to get a job. He is already a felon.
Robbery. I'd like to point out to the court, when he was on probation for that robbery, one of the allegations on his motion to revoke, for which he was revoked and given 10 years, was 2 positive samples, one for tetrahydrocannabinol and all the other for barbiturates. So he at least has some problems with drugs.
July 16. I didn't quite know cases as an adult.
Well, you just said you never had any drug problems.
I never. Just as you said, I feel it.
9 years ago, but
I was a baby. I don't remember.
And you've been
Okay, but now you're not a baby and you're still making the same bad decisions. So listen, here's what we're going to do. If you want to really do what you say you can do, then you're going to get out there and you're going to get busy and you're going to do it. Otherwise, you're going to be in jail. Couple things. Your bond conditions are modified to order that you have a drug patch. You get that drug patch within 24 hours. The initial drug patch obviously is going to test positive, but it shows me quantities, not just that it is, but it's going to qualify it on how much is in your system. Every drug patch, you get it changed every 2 weeks.
And here's where it gets brutal. Gomez insists he has no drug history. But the prosecutor reminds the court he already failed probation with positive drug tests before. Boom. Hypocrisy exposed. And the judge drives the point home. You're not a kid anymore. You're an adult making the same mistakes. This is what I call the credibility collapse. When your words don't match your record, the judge stops listening. So I'll ask you, at this point, do you think the judge should keep giving chances, or was she right to tighten his bond conditions?
If you miss one, if you test positive, obviously, then you're going to have a warrant for your arrest and you're going to go back to jail. Do you understand? If that amount is not going down, you will be back in custody. In addition, you will go find a job. You will prove to me that you are doing that. You need to apply for at least 3 jobs a week. You need to be applying for 20 jobs a week. If you really want to take care of yourself and your child, then you should be out there hitting the pavement every single day, finding a job. Clean up, test negative, go get a job if you have these certifications. Prove that you're not still 16 and making those stupid decisions. All right? I'm going to reset your case. You need to stay in touch with Mr. Lewis. I want proof by tomorrow that you have the drug patch. Mr. Lewis, your bondsman can let you know where you can go get that on. As soon as you leave here, call the bondsman. Actually, before you leave, the probation officer has a list of places that has it. She's going to give it to you right there at that desk. She'll give you a list. You need to go get that on. You need to get a job, start making some money, and potentially be hiring your own attorney. Right now, Mr. Lewis is going to remain your attorney, but I want you to be working on all of those things. Take care of your business. All right?
Thank you so much.
All right. This is your only chance on this kind of stuff. Okay. You're free to go.
Thank you, Judge.
So let's break this one down. Gomez tried to dodge with sovereign citizen tactics, but what actually saved him was a no-show officer, case dismissed. But that victory was short-lived. His bond got tightened, drug patch ordered, job search mandated, and the judge made it crystal clear: grow up or go back to jail. This case highlights a big truth. Sometimes defendants are their own worst enemy. So what do you think? Was the judge fair in balancing dismissal with strict bond conditions, or too harsh on someone struggling? Let us know in the comments. And if you found this courtroom roller coaster as wild as we did, hit like, drop your thoughts below, and subscribe for more jaw-dropping legal breakdowns.